Hello everyone and welcome to today's Mondac webinar in association with Patricios, Pavlou and Associates, who will be explaining the current concerns surrounding the Cyprus private client landscape and discussing how recent threats can be tackled or mitigated. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Stavros Pavlou is the Senior and Managing Partner of Patricios, Pavlou and Associates. Over the last 35 years of his practice, Stavros has become highly experienced in corporate and commercial litigation and arbitration, and he also specializes in cross-border transactions involving banking, finance, capital markets, and corporate and commercial matters. Furthermore, he regularly advises on the setup of Cyprus International Trusts on trust law, asset protection, and international tax planning. Stella Strati is the corporate finance, tax and private client partner. She has extensive experience in corporate and commercial law, mergers and acquisitions, restructurings, tax law and banking and finance transactions across a wide range of industries. She advises important local and international companies and financial organizations, as well as leading international banking institutions on all aspects of financial and commercial cross-border transactions and security matters. Now, before I hand over to the panel, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session, but we do encourage you to get in touch after the webinar. It's now my pleasure to hand you over to Stavros and Stella to begin. Thank you.
Good morning, everyone. If you're in the same time zone as I am, good day, good evening, otherwise. I'm excited to be speaking to a number of people from all over the world. Last time I checked, we had more than 15 countries represented by various people who are listening into this webinar. And we are excited to be speaking to you about our favorite topic, which is Cyprus. We will go over the private client landscape and current developments. Allow me to introduce some basic concepts to start with, and we will be developing them as we go along and explaining how things are these days, so that you can understand where we are at with today's challenges. Next slide, please. Next one. As you may have seen in the wide circulation in the press, Cyprus is a favored destination for people who are high net worth and who are looking for a destination where they can basically do their private wealth planning, their estate planning, their family planning, and because Cyprus is conveniently located, it's at the crossroads of Asia, Europe, Middle East, Africa. People from all over the world are using Cyprus as a good destination. Next slide, please. The first thing people are seeking when they are doing tax planning and family planning is how to set up a trust. Trusts are widely used in Cyprus. They are a preferred vehicle. By way of background, we are common law jurisdiction, and therefore the concept of trust is inherited from the principles of equity of other common law jurisdictions. It's imported as a concept from the UK. It has in fact been called the greatest single contribution of the common law to world jurisprudence, trusts are widely used as vehicles for this sort of planning. Next slide, please. The tax regime in Cyprus has relatively recently been amended in 2012 to bring it into the needs of the current climate and the needs of international business. the law amended has introduced several concepts which are considerably advanced, and they constitute among the most user-friendly legal framework for setting up trust. It's a very easy procedure. A trust is created by a mere declaration of the trustee accepting the office of trustee under the terms of a trust deed. It quite often takes the form of a special company that will undertake the role of the trustee and is managed by experienced professionals. And that company is a limited liability company. It acts as trustees. People can change the trustee at any time through a mechanism that is agreed and included in the trust deed. There are provisions for protectors to ensure that the trust is managed by people who are who enjoy the confidence of the beneficiaries and the settlor, and all the modern attributes you would need to see in a trust are included in our law and can be the basis on which a trust is created. It can include all kinds of assets anywhere in the world, and in fact, it has been used quite widely for this specific purpose. Next slide, please. The requirements for a Cyprus International Trust are set out to ensure that the trust enjoys the tax benefits of having a trust situated in Cyprus. It doesn't mean that if the requirements are not met, the trust is void. It just fails to achieve the desired tax benefit for the settlor and the beneficiaries. For the tax benefits to be enjoyed, the settlor must not be a tax resident of Cyprus during the calendar year immediately before the creation of the trust. Relocating to Cyprus afterwards is not an issue, but the settlor must not have been a tax resident of Cyprus before that. Being resident in Cyprus and being a tax resident are two different things. You may be resident in Cyprus, but still be tax resident somewhere else. So a Cyprus resident who is not a tax resident can still set up a trust. At least one of the trustees must remain a Cyprus tax resident throughout the duration of the trust. Otherwise, it's not considered as if the trust is managed through Cyprus, and therefore it would fail to obtain the tax benefits of having a Cyprus International Trust. And the beneficiaries must not be Cyprus tax residents during the calendar year immediately preceding the year in which the trust was created. Again, they can relocate afterwards, and in fact, many people who are beneficiaries of trust are located in Cyprus or also have ordinary residence in Cyprus. But again, this doesn't mean that residence here is an impediment to their continued presence as beneficiaries of a trust. Next slide, please. As I mentioned, the Cyprus Trust has been used for asset protection. It is quite often the case that people who are in business want to protect family assets by separating them from the actual business assets, and it's always a good thing to do that, to protect family assets from the adversities that businesses might encounter, and therefore you would ideally want to ring fence personal assets from business assets. It's not a recommendation to defraud creditors. In fact, if any property is transferred to a Cyprus Trust for the purpose to defraud creditors, then that transfer would be invalid and you will not obtain this protection. There is an added comfort to the trust arrangement in Cyprus, because if any creditor wants to bring a challenge to the courts to attack any transfer of assets that has taken place with the intention of defrauding creditors, they can do so within 2 years. While the law does not mention whether the 2 years from the transfer of the asset requires that the period starts from the moment the creditor becomes aware of such transfer, it has been discussed among practitioners, and the cautious approach would be to consider the 2 years as running from a time when the creditor could have been aware or with due diligence of the fact that the transfer of assets happened. The burden of proof that the transfer was fraudulent is on the creditor, who must show both the fact that the claim of the creditor or the debt was known. In addition, the financial situation of the debtor was such so that if they transfer property, it would be obvious that the creditors could be defrauded by this transfer, and they went ahead with bad faith and did this. Next slide, please. I will pass on the mantle to my partner, Stella, who is an expert on our private wealth department. She's in fact the private wealth partner of the firm, to explain why you should really set up a family office in Cyprus and nowhere else.
Thank you, Stavros. So there are, of course, the usual reasons why someone would want to relocate to Cyprus and set up a family office here. It's the sun, the sea, the weather, all that nice things you read about Cyprus on the website. But apart from that, Cyprus offers a number of incentives for someone to opt to establish the family office here. First of all, we are an EU member state since 2004. The legal framework, as Stavros mentioned, is based on common law, and this comes with certain flexibility. We do have a very flexible and modern corporate law regime. It's easy to set up a company in Cyprus, it's straightforward. There are no requirements as to the nationality of the shareholders. The management and control test is used for the purposes of a company to be considered as a Cyprus tax resident. That means that the majority of the Cyprus board of directors of the Cyprus company need to be tax residents here, and the important management and business decision of the company should be taken on the island. And also, this comes along with the tax incentives. And what is important for the family office concept is that when relocating managers or higher ranking officers in Cyprus, first of all, these managers, let's say, these officers can get up to a 50% tax exemption if their salary is more than 55,000 euros per year, and this has been reduced in 2022. Before that, it was 100,000 salary. Now it has been reduced to 55,000. So you have a pretty attractive incentive there in that you get 50% tax exemption. But also, we do have the concept of non-dom tax residents, which, as I will explain in a while, offers also some exemptions for people wanting to relocate here. Family offices may opt to be regulated in that they apply to get a license to offer certain regulated services, such as to act as trustees or to act as directors, secretaries, and so on. The regulators currently in Cyprus are 3 separate regulators: the Cyprus Bar Association, the Institute of Certified Public Accountants, and the Cyprus Securities and Exchange Commission. For family office not wanting to apply and to get a license because there are a lot of requirements, they may set up as an international company or to register with the social insurance as holding an investment company, and then outsource to lawyers or to authorized administrative service providers the services that should be offered by licensed professionals. Apart from that, we have been a British colony until 1960. Professionals on the island, and the majority of the people here speak English widely, so it's easy to set up, and the family office here, move to Cyprus, and as I said, enjoy the usual reasons for someone wanting to be in Cyprus. Next slide, please. Now, it is common knowledge that Cyprus is an attractive tax jurisdiction. It is a reality that during the last years, Cyprus has introduced all OECD guidelines and BEPS recommendations. But we do have a very attractive system. There is no wealth tax, no inheritance tax, and no tax on gifts. The corporate tax rate is currently at 12.5%. There is a discussion of increasing that amount to 50%, but still it's only on the level of consultation. So we expected that it will be introduced during the next years, but we haven't reached a stage to see a draft bill. We are only at the stage of public consultation. There is no capital gains tax in Cyprus apart from sale of immovable property, and that includes sale of shares. This is tax-free. Also, dividend income is tax-free. There are no withholding taxes, and as I said before, we do have the non-dom status for people that wish to relocate from abroad and that they do not have domicile of origin in Cyprus. They can relocate, and this status offers them the right that the special defense tax, which is actually a passive tax that is applied on passive income, interest, rents, and dividends, does not apply to individuals who have gained the non-dom status. Also, in relation to personal income, the first 19,500 are tax-free, and then we do have progressive tax rate, and the maximum applicable tax rate on personal income is 35%, which is over 60,000 euros per year. Next slide, please. Okay, the citizenship by investment program is no longer available, but Cyprus offers the PRP program, which is the permanent resident permit program, to investors that wish to invest up to 300,000 euros to either to purchase a real estate property or to invest in companies or funds. We have introduced a few amendments to this program recently in 2023. A person, an individual who applies and obtains the PRP status can also pass it on to the spouse and their dependent children. But people who obtain this PRP status need to prove that they have a sufficient annual income to maintain themselves. This has been set this year to 50,000 euros for the main applicant, and an annual income of 15,000 euros for the spouse, and 10,000 euros per year for each dependent children. The government mentioned that applications under the new PRP scheme can be reviewed within 2 months. To tell you the truth, this seems very optimistic. We will need to see how this is applied practically. I am very curious to see whether we can reach the 2-month target that was set by the government. Now, the good thing is that if you are successful in obtaining the residence permit, the permanent residence permit status, you can apply for the Cyprus citizenship after having being resident in Cyprus for 7 consecutive years. You may apply after 5 years, but additional requirements apply, including the knowledge of the Greek language, which Greek, as you know, is one of the most difficult languages in the world, so that we don't see it so often in practice. And that's it from me for now. I'll pass the mic to Stavros to discuss the most interesting part of today's presentation, the current challenges.
Yes. As you understand, we are operating in a totally new world as from February 2022, where we all are witnesses to what is happening with the war in Ukraine, and the fact that it has spouted a number of problems, not least the humanitarian one, but I am going to be concentrating on the legal challenges and challenges to business, which are the result of the conflict, and how this has affected the landscape in Cyprus and how we operate within this landscape. We are all aware of the existence of the sanctions regime. If I can have the next slide, please. These are only the EU sanctions. Before I start analyzing that, I would like to point out that we also have the US and the UK sanctions, even Ukrainian sanctions, and Russian sanctions, counter sanctions, which are all posing their own challenge. Even though US sanctions and UK sanctions are not applicable unless they have also been adopted by the EU, I would not advise that people actually do not adhere to these sanctions, because the UK and the US has, as recently as last month, viewed the matter as a matter of political decision, and people who are assisting the breach of their sanctions, even if operating in countries which do not have adopted the same sanctions, can still be sanctioned themselves by secondary sanctions to prevent enabling the breach of the sanctions by the subjects of such sanctions. So we have, as I said, as recently as last month, seen the expansion of the US sanctions in Cyprus against specific service providers who were viewed by the US as assisting sanction entities to break the US sanctions. Similarly, the UK at the same time did exactly the same thing against the same individuals for the purpose of making sure that nobody is actually enabling sanctioned individuals from breaking the sanctions. In the EU, we have 2 regulations, the Council Regulation 269 and the Council Regulation 833. Both of them are from 2014 and were originally intended to target the Crimea issue. It has since expanded exponentially, and now they are 2 hefty and difficult pieces of regulation, and we have to adhere to a multitude of prohibitions. It's not only prohibitions such as the freezing of assets, which is the main basis of Regulation 269. It is also prohibition of certain activities, which is the basis of Regulation 833. 833 used to be a very short regulation restricted to restriction of the access to capital markets of sanctioned individuals. Since then, it has expanded tremendously. It now covers a multitude of activities, and people operating in the current world should always carry out sanctions compliance for every transaction they undertake that has any Russian element in it, or any Russia-related element in it. And Russia-related could be that the company they are dealing with has somewhere along the line a Russian shareholder or a director, and or it operates in Russia, and therefore should be always vetted to ensure that there is no breach of the sanctions when actions are undertaken on behalf of this company, or advice is given to this company. The next slide, please. Article 5M of Regulation 833 is directly relevant to what we have been discussing about trusts. A trust where a settlor is a Russian national or natural person residing in Russia, or legal persons established in Russia, then these trusts are affected by the prohibition. Similarly, if the beneficiaries are Russian, there is an exclusion if the settlor or beneficiary is a national of a member state or a country member of the European Economic Area or Switzerland, or it has a temporary or permanent residence permit in a member state. This has been restrictively interpreted by the European Union to mean only if there is one beneficiary and or one settlor, and it's not when you have more than one beneficiaries and only one of them qualifies for the exclusion. Therefore, if the trust falls within these parameters, then as a result, European service providers cannot assist them, cannot provide them with maintenance of the trust, with services related to the trust, with any sort of administration of the trust. It is completely out of the way to offer any sort of services supporting the trust. You have to understand that even when we are asking the European Union for clarifications about this matter, and I have to tell you that this is a very difficult to understand regulation sometimes, even the European Union will answer with a proviso that even though we wrote the sanctions and we are giving you this interpretation, it's only the court that can give an authoritative interpretation. So even if you are receiving some answer from the European Union that this is prohibited, this is allowed, you're still not safe, because only the court can decide. You can, of course, claim that you are acting in good faith if you are in breach of the sanctions inadvertently. A related matter, which is not on the slide, is the prohibition of provision of legal advice. And I'm only mentioning it because this is something that people would come to us for. We can not provide legal advice to Russian entities. We can only provide legal advice to Russian physical persons, unless they are resident or a company with Russian interest is established not in Russia, or it's resident within a member state or the European Economic Area or Switzerland. So people coming to us for advice about their private wealth management, about trust services, etc. All of them need to be onboarded with sanctions compliance checks. It creates a bit more bureaucracy. Our office is very efficient in carrying out all the necessary checks, and we are very responsive at the end. But it is something that people have to go through when they are seeking legal advice or trust services in these days. Very often we are asked questions that we cannot give answers to because there might be a Russian element in it, and we cannot advise if we are not sure whether that advice will end, which creates uncertainty and additional cost and bureaucracy. However, this is the situation everywhere, is not specific to Cyprus. Wherever you are, even if you are in a non-sanctioned country, professionals in non-sanctioned countries are usually very careful not to be in breach of US sanctions, of UK sanctions or European sanctions, or to aid in the breach of such sanctions, because then the sanctioning authorities could sanction them themselves. To give you an example of this, if you are a business operating in Cyprus and you're offering advice and support in breach of US sanctions, if you are sanctioned, our banks will freeze your accounts. It doesn't matter that the sanctions from the US are not applicable here, or you are not a US citizen. Your accounts will be frozen because the banks cannot afford to offend the regulators in the US. They might find themselves without a corresponding bank in dollars, and that would be intolerable in terms of carrying out their business. So there are challenges. The most important message I want to give is that you should make sure that when you're seeking advisors for private wealth reasons, for any matter which includes sanctions compliance, you should make sure that the people you're talking to are experts on this matter. A lot of people will accept assignments without carrying out a sanctions compliance or a full compliance exercise. It's not to the best interest of the client if they do that, because the client and the advisor might find themselves in breach of regulations and laws and sanctions. This is all I want to say about the sanctions part. The next slide, please. Yeah, Stella will now analyze how what I have described as the environment affects family offices.
Thank you, Stavros. Now, it's one thing that is not included in the slide, but is a natural consequence of what Stavros has described is, of course, family offices in Cyprus that used to act for a principle that has been included in Regulation 269. As you can understand, now, most of these offices have ceased operations or have reduced operations because they can no longer deal with the assets of an individual or a family who is under an asset freeze. In relation to challenges that family offices are faced with today, I have to say that discussing with other private client professionals from around the world, we have identified that challenges are more or less the same. I mean, traditionally, family offices operated under a very traditional and complex structure. Usually, you had a few loyal employees. These employees used to deliver the message or the information to another person, and that other person to another person. Finally, that message reached to the principal sometimes. the message received by the principal was not the one sent by the private client professional or the lawyer or the advisor and so on, and communication were sometimes very complicated. I will give you a very simple example that happened to us, to Stavros and I. We were working as a team on structuring a trust. We had a lot of meetings with the people from the family office that was located here. We advised on certain changes that need to be taken place to optimize the trust structure. We prepared the documents. We sent them to the in-house legal team. The in-house legal team said, okay, perfect, this is what we have discussed. And then they said we will get the confirmation from the principals, and then 1 month later they came back to us and said, well, the principal does not read more than 15 pages. So as you can imagine, it's not always easy to deliver the proper advice if you operate in a structure that is complex and does not is not successful to operate efficiently. So this is a challenge that needs to be faced. And we see now family offices that are being evolved in that they, the younger generation, because some younger generation now comes into the picture, and structures are simplified. We need to add value to the structures, and that we need to assess why a structure behind the family office or a structure under the trust or relating to the assets of the family needs to be complicated. We always advise that these structures need to be simple, they need to be simplified, and also family office need to be simplified and more flexible. It is now encouraged that more professionals are employed by family offices that are able to take decisions in that they will assist the family to reach its goals. And it's very important to note that there has been a shift in relation to priorities after the pandemic. The value of health was highlighted during the pandemic, so priorities have shifted from asset protection to succession and planning, because the head of the families realized that, okay, health is fragile, and so we need to plan ahead if something goes wrong for the younger generation to be there and continue the family tradition. Also, we are now more flexible in the way we are working. Connectivity has been improved, so everything now is there through a screen with Zoom meetings and so on. And this mentality has also moved to family offices. And we have a lot of buzzwords now. We have sustainability, we have diversity, we have corporate social responsibility, we have environmental practices. The younger generation of the families require that these practices are also included in the decisions taken by the family office. And also, we see different assets placed under the structures of the family offices. We have cryptocurrencies now, we have IP rights, we have different assets that we also, as private client specialists, we also need to shift our focus and be able to advise on other current matters as well. Next slide, please. Now, this is my favorite topic because every time I discuss this topic, I need to comment on different additional things. Now, we live in the era of overregulation, where substance and transparency are main issues. We have every year we have additional reporting obligations. It's not simply AML, it's not simply KYC requirements. Now we have the sanctions compliance that we need to perform every time we onboard the client, or every time we advise a family or we review a structure, we also need to evaluate whether prohibition apply to the operations undertaken by each company on that structure. So we do have increased sanctions and reporting obligations. We have introduced in Cyprus the Register of Beneficial Owners. As a side comment, I would say that currently public access has been disabled following the relevant decision of the European Court of Justice. And now the BO register, the Cyprus BO register, is not publicly available. In 2022, the Cyprus Trust Beneficial Owners Registry was also introduced. There we are required to include details of the trust, including settlor, trustee, protector, beneficiaries. Similarly, this is private and it can be accessed only by the trustee, the professional trustees who are obliged to make the registrations, and also by specific public authorities. As I mentioned before, trustee is a regulated profession. We have 3 regulators that issue licenses to professional trustees, but also there are some carve-outs by the Cyprus Administrative Service Providers Law, but exceptions to non-professional trustees are very limited and hardly used in practice. So this is the wider environment in which we operate, is the area of regulation of reporting. But as Stavros said, it is of importance to ensure that the professional advisors, the lawyers, the trustees, the wealth advisors are competent and are able to comply with all regulations, obligations, and requirements, because it safeguards the rights of the clients, the principals, the beneficiaries. And in relation to this point, I'm going to address the first question in relation to CRS reporting. The question is whether Cyprus has taken the wide or narrow approach. In accordance with the decree issued by the Ministry of Finance, Cyprus is only required to report on individuals resident in CRS countries, and has taken thus the narrow approach. So we also have an additional question that we will address later on. Thank you very much, and I pass the mic to Stavros to make the closing remarks.
Yes, I think we should first take questions and then we'll do the closing remarks. I see one question there. Dan.
Hi, Stavros. Thank you very much. Yes, we have had a few questions in already, which is great, but please do send in any questions that you have. We have plenty of time now to answer those questions. So I believe, Stella, you just looked at that CRS reporting question, and I'd be happy to turn that back over, Stavros, if you have any other sort of comments that you want to make on that point. If I just read out that question quickly for the audience. Has Cyprus implemented a narrow or wide approach to CRS reporting? In some In some jurisdictions, such as Ireland, they implement the wide approach, and this means reporting on all individuals, including non-CRS residents, to revenue, and revenue decides what information to report. Is this similar in Cyprus? So if you could, both of you, just expand on that point, that would be fantastic.
Stella.
Yes, I have addressed that question. The first question about CRS, I already replied that we have taken the narrow approach. and nor the wider one. And we are also Cyprus is also only reports for CRS country residents.
I don't have anything else to add. We approach it in a narrow manner.
Brilliant. Thank you, Stella, and thank you, Stavros. We had another question in, I think this was in relation to something you were talking about earlier, Stavros. That question is, what if one of the owners of the company based in Cyprus is Russian?
Well, there is no wide rule that excludes Russians from owning shares in a company. They cannot acquire new shares in companies that are, if such shares are issued after the 12th of April last year. But otherwise, they are entitled to participate in companies. In fact, if they are resident in the EU economic area or Switzerland, they are again allowed to acquire even newly issued shares denominated in European currencies. The question most importantly is whether they are sanctioned or not. If they are sanctioned, then for sure the shares they hold will be frozen with whatever result ensues on the company, depending on the amount of control that these shares give to their owner. If there is no control and the company still is a minor shareholder and the company still has a number of shareholders and it can operate, then the company is not sanctioned, is not frozen. If there is control, then immediately the company itself will be sanctioned and its accounts will be frozen. Similarly, if a sanctioned Russian individual is a director of a company, then the banks will refuse to operate unless that director is actually removed, to avoid the possibility of considering the company under the control of a sanctioned individual through its position as director in the company. But generally speaking, there is no legal impediment in Russians participating in companies. The banks and professionals taking instructions will be doing an enhanced due diligence and sanctions compliance process to ensure that everything is compliant with the laws and regulations. Other than that, there is no a priori exclusion of any nationality from participating.
Brilliant, fantastic answer. Thank you, Stavros. In relation to setting up a CIT, if a Cyprus property is held by an individual who settles it into a CIT, would this be considered a transfer for CGT purposes? And if you would like to read that question, Stella and Stavros, before answering, you should be able to see it in the chat function.
Okay, about this question, I would like to say that there is a special procedure for trusts when they hold when immovable property located in Cyprus is transferred to the trust. So there is an application filed with the competent land registry department informing that the transfer will take place and the trust will be placed on the property will be placed under the trust. And following that procedure, there are no transfer fees and no taxes in relation to the transfer of the property to the trust. But it's a very long process. I might add.
If the property is located in Cyprus, then normally the transfer of property or the transfer of shares in a property owning company or structure will attract CGT. In the case of a trust, as Stella said, you go through a process, you provide the necessary information, and to the extent that the transfer is within the transfers which would not attract CGT in the first place, then you get an exclusion. But if you are, for example, if you are settling into trust which actually belongs to somebody who would not qualify as a person to whom a free transfer could be made, such as your immediate family. If for example you are a friend has set up a trust and you want to benefit your friend by transferring property and to him, then you do not avoid CGT simply because there is a trust, because the person to whom the transfer is made is not one to whom it could be made freely.
Brilliant, thank you.
What I mean, which is important to understand, is that trusts should be used legitimately for their normal purposes, not as devices to avoid the consequences of the law or the tax legislation.
Brilliant, thank you, Stavros. We've got some great questions in. As I mentioned earlier, though, if you do want to get in contact with Stavros, with Stella, with the firm afterwards, we will be sending their contact information onto you after this webinar, but please do send in more questions that you have. We've had another one in. How is Cyprus treating companies related to crypto, so receiving crypto payments or working on blockchains? Are there any restrictions or special permits?
We are not regulated in terms of cryptocurrencies in Cyprus, and therefore our banks do not accept money coming out of crypto wallets. The fact that you have a crypto wallet, of course, and you're operating yourself is not regulated either. But you cannot transfer from from realization of cryptocurrencies into your bank accounts in Cyprus easily, because the banks are unclear about the regulatory framework, and the AML procedures would be difficult for them to carry out, and therefore our banks do not deal with cryptocurrencies right now.
Brilliant, thank you very much. Now, Stavros, Stella, I know that you have another slide that you want to speak on. Are you happy to take a couple more questions before we move on to that? Excellent. And I think that you touched on this earlier, has Cyprus been impacted by the sanctions imposed due to the war in Ukraine?
Well, we have covered that. Cyprus has an unfairly enhanced bad reputation with regard to its dealing with Russians in the past. The reason I'm saying unfairly enhanced is because really the money is not being spent in Cyprus if it's passing through Cyprus. It is being spent in London, in German shipyards, in London Grad to buy property, in France, the French Alps, in Switzerland. It's not, people are not actually just buying property here. So everybody in Europe was dealing with Russian money. It's not just Cyprus. Cyprus has cleaned its act tremendously. We have enhanced, even to the point of over-regulation, we have enhanced screening procedures and sanctions compliance and AML compliance, and the regulator is quite strict, and the professionals are doing their utmost to create the proper perception about Cyprus. Cyprus is fully compliant to the law and regulations. This means that as a result of the war and our need to comply not only with EU sanctions, but also US and UK, because of our banking system here complying with US and UK sanctions, we are not a friendly country for people who want to either avoid the sanctions or do structures which intend to sidetrack the sanctions. We apply strictly the relevant laws and regulations, and it is a criminal offense to assist people to circumvent the sanctions. This meant that a number of important clients and large organizations from Russia which were using Cyprus are no longer able to do it. And this is the reality. So yes, Cyprus has been impacted, but from the next day that this situation started developing, Cyprus professionals have been going around the world. I mean, I can give you an example from our own firm. We had 6 teams out in May to various conferences, seminars, and other countries to make sure that we are able to broaden our client bases and our footprint as service providers, as legal advisors, and as advocates to non-Russian clients, so as to avoid the impact on ourselves of the fact that a number of people can no longer use Cyprus. There will be professionals who will suffer as a result, who do not have the resources or the profile which will allow them to attract clients other than the ones they were servicing. But the majority of people who are serious players in the services industry will be able to attract work from elsewhere. And in fact, we are already seeking work from other areas of the globe to very good results, I must say.
Excellent, brilliant. Well, looking at the time, and I can't see any further questions in at this time. Karen, if we could move to the next slide, please. I know that you have this final slide that you want to speak to before we close today's webinar. So I'll hand back to you, Stavros, and you, Stella, to speak on this final slide.
Just a couple of words from me, and Stella can add to that to close off the discussion. Cyprus has always been an attractive private client jurisdiction. It has a tradition going back to way before the situation we are faced today. We were offering our services to people in the Middle East, to Europe, to UK, to Asia. So it's not as if the current situation is changing either the ability or the appetite of service providers in Cyprus to provide the same high standard of service. Yes, there are challenges, but I firmly stress that Cyprus remains and continues to be a very attractive private client jurisdiction, and clients who are seeking a legitimate, properly regulated environment in which to set up their family offices, their trusts, secure that they will not suffer from headaches and enter into misadventures, then Cyprus is very attractive and will continue to be.
My only comment to that is choose your local advisors wisely. That's all from me. Many thanks.
Excellent. Thank you very much for that, Stella. I can't see any further questions that we've had in today, but I would like to thank you both from everyone at Mondac for your insights and your thoughts today. It was a really interesting webinar. We really appreciate your time and your effort putting that together. To our audience, I would like to thank you as well for being with us today. As I said, we will be following up with you contact information for the firm, for Stella and Stavros. We really do encourage you to get in touch afterwards. We will also be sharing the slides with you and a recording of the event. So please do share those with your colleagues, anyone that you think would find this of interest today. So once again, thank you very much to everyone for joining. Thank you to our panel, to Stavros, Stella. Thank you very much. I will wish you all a good day and say goodbye.